Welcome to one of the SAIS iLaw presentations on COVID-related issues. Today we have human rights and data privacy issues. Adele Barzelay, one of my former students, I'm very proud to say, and actually one of Professor Schneebaum's former students, class of 2017 in DC, will be presenting. We are very proud and excited about this. Adele is a governance analyst with the governance practice in the Middle East and North Africa division of the World Bank. And she's co-leading the regional work on data governance under the M&A Tech Initiative, and has been contributing on global reports on data governance within the World Bank. And this is an issue, an interest that she has developed over the last 3 years, and is very particularly interested in developing legal and regulatory frameworks to enable sustainable and trustworthy digital transformation of government geared toward leveraging existing and emerging technological opportunities while governing and protecting data and digital rights, which is particularly important given what's going on with COVID. So who knew this would be so incredibly critical right now? So I'm glad someone's thinking about the governance part of this. Prior to the World Bank, she worked in international law and human rights in London and political risk in Washington, D.C., and has published a very important, co-authored a very important report with Bennett Freeman, which I shared with my class last week, on human rights defenders and the important leverage businesses can use in protecting civil society and civil discourse. And she is admitted to the New York Bar, obtained her law degree from the University of Oxford, and last but not least, of course, got her MA in International Economics and Middle East Studies at SAIS. You are a Bologna graduate, so you're a Bologna 2016, I think, I believe, and DC 2017. You made the mistake of taking my class in your last semester. I hope you don't regret it. And you were on the SAIS European Advisory Council from 2017 to 2019. I still have your paper, Adele. With your letter to Zuckerberg. So she was already interested in ICT issues even then. Letter to Zuckerberg pillaring him on the claims that his company was just a tech company and not a media company. And that he had no responsibility for content control on his platform, which you thought was absolute BS, and basically in a very firm but diplomatic manner told him this after Brexit and the US election. So I did a wonderful Blackboard, keeps these things, and I downloaded and reread it with pleasure, but it was a very good paper. To get to today's subject matter. We talk a lot about human rights and privacy, human rights issues in the relation to COVID, but the right to privacy is one that is extremely important. And those of you who may not be conversant in the UN conventions and iLaw mavens, just to root where this is all coming from, there is a right to privacy in Article 12 of the Universal Declaration of Human Rights. So no one shall be subjected to arbitrary interference with his privacy, family, home, correspondence, nor attacks upon his honor and reputation, and everyone has the right to the protection of the law against such interference or attacks. So even in those days, there was a right to privacy, although they weren't thinking in terms of data privacy and digital privacy the way we think today. Same kind of article in the International Covenant on Civil and Political Rights. But to move forward to what has happened in Europe, the Council of Europe in 1981 had a convention for the protection of individuals and in regard to automatic processing of personal data. And the OECD also has guidelines. OECD has guidelines on everything, and they're really exceptional, governing the protection of privacy and transborder data flows. And there they say, the expression of data privacy in various declarations varies in degrees. All require that personal information must be obtained fairly and lawfully. 2, used only for the original specified purpose. 3, adequate, relevant, and not excessive to purpose, and this is very important, accurate and up to date, and we'll talk about this, destroyed after its purpose is completed. So, in the age of COVID, where governments and the private sector is running around with all sorts of proposing different apps for us, tracing apps and apps to figure out who to stay away from and who we can go out jogging with, and what happens to all that data, is the subject of what Adele has been working on for a number of years, not on COVID related, but at least somebody has been thinking about this. So without further ado, Adele, the floor is yours.
Thank you very much, Nina, for the very kind introduction. I'm glad to see that things I did in first of all, your class was very much formative and actually took me down a different trajectory career-wise than I thought it would after SAIS. So, and the work I'm doing at the bank, I think in a way is really at this nexus between the business human rights work I started doing in your class and then with Bennett, and then taking those lessons and applying a human rights approach to the tech sector, and from a governance standpoint, but I'm particularly interested in the human rights and in applying a human rights lens to these issues. Obviously, I work, as you mentioned, I work for the World Bank. I've been working in the MENA region for a long time. I think we'll jump into the substance very soon, but one of the points I wanted to highlight as to why I think this is a particularly important topic, as COVID aside, is that really fundamentally data protection and privacy, and we can have a broader discussion about the concept of privacy perhaps in the Q&A, but really fundamentally it's about trust, and it's about fostering trust between states and citizens. Coming from the MENA region, both having been a Middle East Studies concentrator at SAIS and then working on the region for the last 3 years, that trust and that social contract between states and citizens has been eroded for years. And so in these instances where you have a significant crisis, such as COVID, a pandemic, uprisings, etc., when you start with a weak trust environment, the importance of these safeguards and data protection being one of them becomes all the more important if you are to engage citizens and ensure that they participate in this, trust institutions, and also trust that government and the private sector will do what's right to collect the relevant data that needs to be collected, but also ensure that it's done in a responsible way. So I think this is definitely, I'm glad to have this opportunity to talk about this now, because I think the COVID crisis raises acutely some of these issues, but they are much more fundamental, and they go back down to very, very key concepts, such as trust, such as agency, control individuals want to have over their own their data, but it goes beyond that. It's about agency over basically what they sense is a part of them. So I think that this is, it's based on what I've done since I graduated. I think I've worked in that nexus between taking a human rights approach to a lot of these governance issues, thinking about these questions in terms of sustainability, corporate, but also state responsibility. And I think that what's been very interesting for me working in an organization that is part of the UN system but is not a political organization, is that there has been room, at least intellectually on the work I've been doing, to think about these questions in terms of a rights-based approach. That said, I have to be very clear that everything I'm saying today and all of these thoughts are really my own. I'm not talking on behalf of the World Bank. Happy to answer questions bilaterally or downstream about some of the work I've been doing, but all of this is really my thinking over the last few months, having been really kind of deeply in the subject, and so all views are my own. So having introduced the topic this way, I think the first place to start really is about why COVID raises particular challenges. As I said, I think this is just a symptom of a broader set of challenges and constraints that really fundamentally relate to the relationship between states and citizens. However, obviously, and COVID is not the first pandemic, it will not be the last pandemic we see in the world, but what is true is that it really is, because it is global. If you look at the past pandemics, MERS, SARS, they were pretty geographically contained. This really is, in terms of global scope, the largest, it results in the largest global data collection exercise we've seen to date. And one, because of technological advances where the private sector has played a significant role and a bigger role, I think, in terms of data collection and processing than it has in the past. And so, and this is particularly the case when we're seeing an evolution and a shift to health monitoring and response that combines or includes public-private partnerships from one standpoint, but also that the technological solutions that are being used to monitor and respond to the COVID crisis are increasingly using more advanced technological means, including AI-based algorithms, which raise a whole host of new challenges. So, and I think what's important to remember is that the crux of the matter isn't just about the data collection at the time of the acute crisis. One of the key problems and risks, really, and challenges is that the data that's collected today, unless it's responsibly used, stored, and then destroyed, and we'll come back to that, one of the biggest risks is that it might be misused downstream, and it might be collected and used for purposes completely different than what the original purposes the data was intended to be collected for. And really, it's fundamentally about what we understand that in a situation of crisis, some fundamental rights will need to be derogated from in limited circumstances, because we're dealing with a bit of a tension between, individual rights and the collective good, and the requirement to ensure that we are protecting our world collectively and responding to this in a coordinated and globalized manner. The question is, under what circumstances do those derogations count as legitimate? And what safeguards can we put in place to ensure that the responses we put in place today will not either be subject to mission creep or end up, through inertia of the legislative process, lasting much longer and being misused way beyond the acute time of crisis. And I think one of the points I'd like to raise for reflection and potentially discussion in the Q&A is really this question that we've been seeing time and time again in the media in the last few weeks, which is, is there really a trade-off between data protection and an effective response to this pandemic in particular? A lot of news outlets have been basically positing this as a trade-off. What I argue, and I think falls squarely within the conception of a rights-based approach that is anchored in our human rights frameworks, but also in the business human rights approach to thinking about these questions, is really that the rights-based approach means that you do not trade off certain fundamental rights. And I think that it is possible, with the right safeguards in place, to enable the use of this data for the intended purposes that are needed for COVID response, while ensuring that those fundamental rights are protected. And so hopefully during this presentation, I'll be able to show you a little bit of a flavor of how these safeguards can be put in place to ensure that we are able to achieve both objectives. So mine is moving. I still don't see the next slide on the screen. Apologies for the tech issues.
That's okay.
We've skipped a slide, hang on.
Right.
Sorry. Okay. So, Nina, you very helpfully laid out in your introduction the kind of broader context around privacy and data protection. And I think for now, all I would add to that is the fact that the right to privacy is a right that is distinct from data protection. It's the broader right, and its conception and the way and its scope is very dependent on the jurisdiction in which it is developed, as well as the kind of broader overall culture. So if you look at how the right to privacy has evolved in the US, for example, compared to the European context, the fundamental underpinnings of the concept are very different. In the US, it's a lot about the right to be left alone and the right to have your personal liberties not infringed upon. In Europe, it's more the underpinnings are slightly different, and the cultural background stemming from kind of World War II and the need to ensure that civil liberties and fundamental rights are protected came from a very different context. And I think it's important to remember that law and regulation isn't created in a vacuum, as we all know. It is very much created and informed by the broader socio-political context in which we operate. But fundamentally, we are taking, in this talk at least, a rights-based approach to this. I'm not following the European model on GDPR to the letter, but a lot of the principles that are enshrined in GDPR, which is the European data protection regulation that was passed in 2016 and enforced since 2018, and that regulates all automatic processing of personal data and ensures the protection of data rights associated with personal data across the EU. Though a lot of those principles that are enshrined in GDPR actually come from the OECD principles that you mentioned and the UN Convention on Data Protection and Privacy. And so at a principle level, there's a lot of convergence. When it comes to how these rights are actually enshrined in practice, there is divergence across different jurisdictions. Really what I'd like to leave you with this at this stage is that ultimately we can talk about the substantive and the procedural rights and obligations that data protection regimes afford to data processors and data controllers on the one hand and data subjects on the other, those who provide their data, us individuals. But really what it is, as I mentioned, it goes back to two main things. It goes back to agency, and really what individuals want is control and agency over their data, how it's used, making sure that they know it's used responsibly. And why is that important? That's important because from an individual perspective, it's a lot of people would consider this to be a fundamental right. From the government perspective, really, even if you're being, the most cynical in the world, fostering trust in the system is fundamentally important to governments, because without trust, without individuals trusting that government or the private sector will be responsible in the use of data that they've collected from individuals are likely to not trust the system and not be willing to give their data in the first place. Now, why is this important, particularly in the case of COVID? It's particularly important because particularly when we take the example of contact tracing apps. Contact tracing apps, if they are designed in a way that meets current good practice, one of the key principles is that they need to be voluntary. Mandated use of these apps is considered to infringe upon fundamental rights. The fact that it requires voluntary use means that people need to trust the system, because if they don't trust that the data will be effectively used or responsibly used, they will not use the app in the first place. And in terms of thinking about how these apps fit into the broader health surveillance system and process, data has suggested that you need at least 50 to 70% of users using these apps in order for them to effectively be able to trace contact. So really, trust that stems from responsible conduct, government and private sector conduct, is essential in that data value chain to ensure usage. And that really is what I think fundamentally data protection is about. It's trying to create that trust framework. So again, there might just be a lag. Do you see the next slide?
Yes.
Okay, perfect. So a rights-based framework, we've talked about it. I'll skip over this, but the point of this is a rights-based framework such as GDPR sets out a series of obligations on those who collect and process data, and provides a series of rights to what we would call data owners or data subjects in the case of GDPR, which are basically individuals who provide this data. Some of them that are particularly relevant to the COVID response are principles that, as I mentioned, are enshrined in the OECD principles for automatic processing, the UN Convention, et cetera, et cetera. They include the fact that, good practice dictates that you should only collect the minimum amount of data you need for the intended purposes. So that is the data minimization principle. Another very important principle is that you need to ensure, there's an obligation to ensure that the data collected and processed is done lawfully, but also that there is purpose limitation. So ex ante, there needs to be an agreement of what specific legitimate uses the data will be used for, to avoid this issue of mission creep downstream, of data being collected for one purpose being used or misused for another. For example, data collected or scraped from social media websites then used to surveil vulnerable groups, such as human rights defenders or indigenous people and or other LGBT groups, et cetera, et cetera. There are some other important rights, and really one that I'd like to highlight is the right to redress and review of these decisions. This was a particularly important issue and challenge with the app that was developed in China at the very early days of the coronavirus response, where the app used, there were a number of issues with the app, but one of the problems was that there was a lack of transparency with the algorithm that was used to calculate whether you were green, orange, or red in terms of your health status. And so if you don't have a right to review, you can't challenge any of the decisions that are made on the basis of the data that is collected by you, particularly difficult when it's not made by a human being, but it's made by an algorithm. And we can talk about algorithmic bias in the Q&A if that's helpful. But really, the right to redress is a particularly challenging one, because you need to, it's a kind of a two-step process. You need the right to redress, but you also need to have a strong rule of law system, particularly if you are going to have a system where you might have a right to review and redress within the agency that is making these decisions, but then you might need to have a judicial review process through the courts. So this goes to show that, you can have very robust data protection mechanisms on paper and in the law, but then if you don't have a strong legal system and a rule of law system around it, and if the whole ecosystem isn't strong, the overall chain is weak, and it does affect ultimately individuals' ability to be protected. So finally, I think the only thing I would end on is that in addition to these substantive rights, there are a series of procedural good practice principles that data protection and a rights-based protection framework needs to follow. They're really fairness, transparency, and accountability. You want to know how your data is being used. You want to be able to ensure that there is recourse, and ultimately that there isn't discrimination against you as an individual or a vulnerable group, and that decisions are made on a fair basis. Now, this is my pet issue, and it's something that we can have a longer discussion about in the Q&A, but really one of the challenges that we're seeing in this COVID response, and it's not, COVID is just an illustration of it. These challenges are actually broader, and they relate to the way in which technology has evolved since data protection frameworks were developed, including GDPR. But in the case, to bring it back to the COVID discussion, I think there's one of the key challenges that the apps and the technologies that are being used to track and monitor health in the case of this epidemic are increasingly using technological means such as AI-based or algorithmic-based technologies, or data that is being not collected directly by healthcare providers, but actually being collected, through social media scraping, through using your travel history to know whether you were at a hotspot, et cetera, et cetera. And so technically, what we're talking about is we're moving away from volunteered data that is volunteered by me, an individual, and provided consciously to a data collector. And what we're looking at instead is an evolution towards passive data collection and data scraping, where one of the fundamental principles in data protection is this notion of consent, that you should be able to consent to the data that's been collected about you. Well, that notion is being progressively eroded as we move towards automated decision making, and we're moving away from direct data collection to more passive means of collecting data, and that data collected from one purpose being used to track and monitor health in a completely different purpose. There is a very interesting survey that was done recently in March by Oliver Wyman, showing that basically 50% of people polled in the US would be willing to have data collected, let's say, about whether they went to see a doctor or healthcare provider about data protection, about their health status, but only a third would be willing to have other sources of data, such as airline, airfare or airline travel data be collected for such purposes. So it really shows that we as individuals are comfortable with certain aspects, but we would be much less trusting when it comes to the types of data that are currently being privileged and used to collect data to help, you know, with contact tracing and other means. The second point that I want to make is one of the biggest challenges with the current system is that a lot of times you'll hear that data is protected if it can be anonymized and aggregated. And so as long as the data, you know, as much data as you want can be collected, but as long as it's anonymized and aggregated at the source, we're fine. This is problematic from a number of perspectives, and I don't want to go into a long conversation about it because it'll get us off track. But one of the key issues I wanted to raise for your thoughts, and I think perhaps discussion downstream, is there are different kinds of data that can be used, and some are better than others. So using location data is inherently problematic from a data protection standpoint, such as using call data records that are basically signals from cell towers to figure out where people were. That is even if they're anonymized, it's very, very easy to re-identify them and basically figure out who those individuals were. And if you read that wonderfully frightening New York Times article over Christmas that basically used GPS tracking across months and were able to figure out where everybody was, including, you know, people going to the Pentagon and others, it doesn't take very much to do that, particularly when you're dealing with trend data. So the way in which new COVID-related technologies are evolving is to move away from using call data records and other forms of geolocalization, and are using techniques such as Bluetooth proximity tracing, and we can talk about that in a bit. But that's just this is one way of showing the limits of anonymization. It's super easy to re-identify people. And then I think the key challenge that we have to think about is, as much as we say that data minimization and aggregation are ways to protect data, when you think about this COVID response, there's the acute phase of the crisis where data needs to be collected for specific purposes, contact tracing, making sure, you know, figuring out hotspots, etc. But there's a whole host of different uses that come at the next longer term phase, where actually I think the most important use of this data is going to be for research, to learn lessons from this pandemic and be better prepared for our next pandemic. And for that, we might need more granular data than would be otherwise afforded if we anonymize and aggregate data. You might need to have specific characteristics such as gender and health in the data that is collected if you want to make really informed decisions and improve basically outcomes and research for healthcare outcomes downstream. And so I hope that, I mean, and I'm not the only one, there are lots of researchers working on these topics, but it's really about how do we rethink data protection so that the fundamental rights are protected, but the techniques that are being used are more adapted to thinking longer term and thinking about how tech has evolved that is now eroding or limiting some of the effectiveness of current data protection mechanisms. So I'll move on because I'm conscious of time. I wanted to highlight here we've talked a lot about different technological solutions kind of theoretically, but I wanted to provide you with 3 examples of contact tracing apps that have been developed in terms of responding to the COVID crisis. There's the Singapore Trace Together Act, the recent app or operating system that Apple and Google have collaborated upon, which, by the way, aside from COVID, this is unprecedented and raises a whole host of antitrust and competition issues downstream, but we'll table that for now. And then there's really an example that I find really interesting. MIT was one of the first to come out with this type of app that tries to provide more control to individuals, called their Safe Paths app. I won't, unless it's helpful for me to go in detail about these apps, I'm happy to provide the slides. I think really what's key and distinguishes them is that the Singapore one was very centralized. It was mandated by the government. It was very effective from a government efficiency perspective. There were over 1 million users on the app. But the way in which it worked was to collect data, store it in a central government database, and link that database with a database of contact details of people, so that they could figure out and directly contact people who were in proximity or to people who were then found to have contracted COVID. Now, this is extremely problematic from a data privacy perspective or data protection perspective. The unified database increases the risk of misuse of data. If those data sets were linked and misused, you could basically identify individuals on an extremely granular basis with direct data. So government efficiency wise, fantastic. Singapore is often touted as one of the country models that has managed to eradicate or at least control the pandemic very efficiently, but it comes at a cost. And this is an example of that cost. By contrast, the MIT app, one of the very cool aspects of it is that the data that is collected by the app is stored on your personal device. And only if you are found to have either been infected or infected somebody is the relevant data released. So you're not releasing data by default. You're actually storing the data unless and only the minimum amount of data required to respond is released. And it's completely voluntary, and all that data is then redacted. So from a privacy perspective, that's super important. And what I want this slide to illustrate is that as much as we want to work on the legal and regulatory framework to make it robust, it's also extremely important to be integrating privacy by design techniques into the development of these apps and these technological solutions, because first of all, there's a lag between, the legislative process takes time. It requires effective implementation to be actually effective. The best way to protect data is don't collect data you don't need, so that you don't have to deal with issues about storing it. And the more we work together with the tech world to create standards of safety, the more protected we will be at the source.
Before you go to the next slide,
yes.
Just want to ask you, so this app that Google and Apple have put together for Singapore, I suspect that they're using Singapore as a test case so that they can then apply it to the United States. Are they starting to apply this? And it's interesting in that in our class, we talk a lot about how Apple and Google do not have a rights-based approach at all in the way they do business. And so it's a pity that they may be making the same mistakes while you have an MIT group that's actually taking data privacy very much more seriously.
So the operating system that Apple and Google are collaborated on is actually supposed to be a global good. And it's tested in Singapore, but it's supposed to be used in other. They've made the code open source so that it can be replicated and can be, built upon by other app developers. It meets good practice. So the EU recently published a toolbox on responsible app development and data uses during the COVID response. And it provides a unified approach across the EU to provide guidelines on how to do that. One of the key features of the Google and Apple app is that they use this Bluetooth proximity tracing rather than using call data records for geolocalization. And so in that regard, they are complying with what is currently considered to be good practice. There are some technical limits. I mean, I work on this stuff from a human rights and a legal and a governance perspective. I'm not a technologist, so I can't go into the details of the keys, but my understanding is that they have developed a number of other ways to protect the data that is of some efficacy but limited, such as they have a series of keys that rotate so that you don't have one key, and so it's a way of making sure that it makes it harder to track back to individuals. However, from research I've done, it seems like it's just harder, but it's not impossible to do. So it's obviously limited in its efficacy. I think that, and you can attest from my paper to Facebook that I'm not exactly, I'm as militant as, they go in some of these areas. But I think that what's clear I don't think either Apple or Google are being saints or in providing a public good for, general, there's definitely a business case behind this. but in the sense that they are, they've made their code open source and they're trying to integrate some better practices, I think that it's encouraging to see some of the steps that are being taken. But it's obviously not, I don't think, for a number of reasons, including very practical reasons, such as an issue that I want to raise, because it's something we don't often think about when we're kind of stuck in this debate, is how this evolution is actually contributing to the digital divide. The more we use high tech to help trace and respond to this crisis, the more we leave out people who don't have access to the latest iPhone or Android device and the latest operating system. And this is actually one of the bigger problems with the Apple and Google app. It doesn't work on older operating systems. So by default, the populations that we know are already more vulnerable: African-American population in the US, poorer populations, women who may not have access to phones in the developing world will not be able to benefit from the use of these technologies. And we risk further exacerbating the digital divide that is already just happening by virtue of our technological advances. And that's a really, I think, a very fundamental point that gets overshadowed as we're dealing with a challenge where currently big tech are the players that have the most data storage, collection, and analysis capacity. And so we're using them in the time of crisis. Governments are trying to collaborate with these companies in a time of crisis because there's a need to be expedient. But it does raise questions about how sustainable this is in the long term, and is the data that we're using inclusive? Or is it actually cutting out large portions of the population that are actually the most vulnerable? And are we contributing to exacerbating challenges today in our acute response that will really have ripple effects downstream?
Wow, thank you.
So I thought that since we were going to talk I was asked to talk about data protection, but also broader digital rights, I would end on some broader fundamental rights that are at risk of being eroded in the time of COVID. Generally, we talked about some of these procedural rights, fairness and non-discrimination. So I won't go back into it. Happy to talk about algorithmic bias further in the Q&A. One I wanted to focus on is really freedom of expression, because what's been really interesting, in addition to just kind of a rollback of procedural rights in the emergency context, we've seen a similar rollback in terms of access to information legislation, or request for information, or freedom of information, however it's called in the relevant jurisdiction, legislation. Now, this is an interesting area because we often think about it in terms of freedom of expression. It also has a very important link with data that we often don't think about unless you work in the field. From a very technical standpoint, we talk a lot about open data and how useful open data is for civil society, journalists, researchers, even the private sector in terms of using open government data. A lot of governments' open data portals are pretty poorly designed and don't include a lot of data, or data that's either accurate or easily accessible. So often freedom of expression, access to information requests, or freedom of information requests, are the main way that those groups use to access government data. And this is important from a general research standpoint, but it's all the more important in countries where there isn't a culture of transparency and accountability. Government is closed. There isn't freedom of expression in terms of diversity in media outlets is pretty limited. And there is a very clear barrier in terms of information provided by government to civil society. And so when you see a rollback of this legislation, it could either be justified in the sense that, civil servants are now all being refocused, having their work refocused on responding to the crisis, and therefore can't be expected to respond to access to information requests to the same frequency and degree of regularity as you would expect in business as usual times. But it could also be a sign of attempting to basically limit the truth, particularly reporting about official statistics about the extent to which the government is responding well or poorly to the coronavirus. And this is not limited I mean, we've seen attacks on our media in this country too. This is not limited to authoritarian regimes. But we are seeing, this is to me a very fundamental challenge that often gets put by the wayside when we're focusing on surveillance and privacy and all of these aspects. So since I just mentioned surveillance and internet shutdowns are two other big challenges that arise as a result of COVID. Neither of those areas are my area of speciality, but happy to have a discussion. I know that you and your class have covered a lot of these topics. And so happy to bring ultimately, I think they all come down to data protection. Happy to bring my flavor to those discussions if we want to talk about them downstream. And finally, I think what would be very interesting, probably for Stephen in particular, our constitutionalist and lawyer, just expert in the room. I think one of the aspects that I think is super important is thinking ahead. We talked about the acute phase of this crisis and then some of the risks that spill over into the next phase. And this to me is really where we're at a crossroads. We can either do this responsibly, or we are risking to create the building blocks that will lead to further erosion of fundamental rights, procedural rights, rule of law that will have devastating consequences for the longer term. One concrete example of this is that a lot of countries, particularly actually also in Europe, that are subject to GDPR have had to pass emergency provisions that derogate from some fundamental rights to respond to the coronavirus. This is something that is legal. If under Article 15 of the ECHR, states have the right to derogate in exceptional circumstances to some of their obligations, but you don't get to derogate from core fundamental rights, and it has to be done in very specific, legitimate circumstances. Now, we've seen countries do this. I gave a few examples. The UK coronavirus bill was actually, the UK's Commission on Human Rights wrote a scathing commentary on the bill, particularly because there were two main reasons. One, it was basically it was aimed at being a bill that was meant to provide powers to contain the coronavirus, but it was drafted in such a broad way that it extended to being able to ban all public meetings, shut down airports, detain individuals suspected of being infectious. We are basically giving the police the prerogative to imprison people who might have coronavirus. And so, if you think about it theoretically, it could sound legitimate, but and we know from experience that this can lead, it opens the door to basically significant risks. So I wanted to end on the fact that there are the ways in which we can make these derogations legitimate. First of all, we have to remember the importance of the rule of law principles on lawful, necessary, and proportionate response. And if you don't mitigate, or at least pass those tests, it's very likely that you're going to end up drafting an emergency provision that may have long-lasting consequences and doesn't meet rule of law standards. It was super important to ensure that there's independent review and oversight, as well as redress for misapplication of these provisions. And one that I think is fundamentally important is the need to ensure that there is a very, very strictly drafted and strictly applied sunset clause to these laws, these emergency provisions. And usually I think 12 months is considered to be best practice, even if it has to be reevaluated downstream. But that is really a key aspect. And then finally, I want to end and open up, because I know, we started with your class in your introduction. I wanted to end on it. And I wanted to show just how much I've been privileged to be able to basically combine the different streams that I've studied into how I think about this issue. And I actually think that the business and human rights approach is a very useful way of thinking about those broader governance questions around data protection, the social contract, what are the roles, responsibilities of various actors, government, the private sector, civil society, I think the business human rights approach is all the more important because of the outsized role played by the private sector in this response, and the lack of, basically the lack of regulation, particularly of big tech, and the reliance on self-regulation, codes of conduct, and other voluntary mechanisms that only work if the actor itself is responsible. And I wanted to highlight the guiding principles. I'm sure we'll have a discussion about them. But really, I wanted to highlight a concept from the course that I took with you and from the field that I've then worked on with Bennett, which I think is really useful to explain that trust framework that I talked about at the beginning. And really, it's about creating a social license to operate. In what conditions and under what conditions can the use of data be responsible while achieving or enabling the achievement of stated policy objectives? And that is both for individuals, but also for groups. And that's one final area where the field of data protection is evolving, which is very, very interesting. We're moving away from thinking about data protection just from the perspective of individual rights. And in order to really be cognizant of the realities on the ground and how data is being used and the insights being derived from data, we need to be thinking about not just protecting individuals, but protecting groups. So I'll end on that. Happy to answer any questions, and I really look forward to the discussion.
Thank you, Adele. That was a phenomenal overview of sort of the state of play right now, and I feel much better that you are working on something like this, because the United States is going to need you as they
it keeps me up at night, so.
days come up with a GDPR for itself. And obviously, I think both Professor Schneebaum and I are our hearts are so happy to hear you look at things from a rights-based approach. This is music to my ears. I had a quick question on you spoke about what's going on in Europe. And in the US, there is a real problem, because after 9/11, there was a lot of intelligence gathering, and the powers are still in place, no sunset clause whatsoever. And there is a group in the Congress that's working on some of these issues, but to this day, we still don't have any kind of regulation, federal regulation, on data protection. We were talking yesterday about California. Maybe you can talk about where we're heading in the U.S. And I just wanted to quote Senator Maria Cantwell, who says, "Rights and data surrendered temporarily during an emergency can become very difficult to claw back." And this is the big issue. I am very concerned, because I did a little research here and saw that Peter Thiel of Palantir is a data analytics firm, has gotten a contract from his buddy in the Trump administration to build a database to track the spread of the virus. So I don't have much faith in Peter Thiel looking at things from a rights-based approach. So if you could take those two questions.
Sure, let's start easy.
And then please, taking Q&A, I'll be looking at the Q&A and feeding them to you. Please leave your name and school affiliation, or if you're a graduating senior with your question.
Perfect. Thank you, Nina. And actually, thank you for the example about 9/11 and the Patriot Act, because that is exactly one of the examples of legislative provisions that were passed in an emergency and were not drafted in following those principles, such as, basically ensuring that it was lawful, necessary, and proportionate, and not having sufficiently strictly applied sunset clause, and engaging in, therefore, mission creep. And everything we've seen since the creation of the NSA, the surveillance culture in the US, and how that has spiraled is a result of legislation that was passed for a very specific purpose. There was actually a very good article a few weeks ago by a long read in the FT, which I highly recommend everybody reads, by Yuval Noah Harari, on basically the kind of longer term vision and the world after coronavirus. And he gave a series of examples of similar to this one. He gave an example about his home country Israel, and how some legislation that was passed during, you know, the 1948 Arab-Israeli conflict is still now being used today to justify certain aspects. And in fact, Israel is one of the countries that has been using its surveillance, its intelligence surveillance technology to and adapting it for the corona response. So we see this time and time again. It's very worrying, and that's exactly why I wanted to make sure that I had this section in my presentation on how, in what circumstances are these derogations legitimate, and when they are not. On California, so the U.S. is in and this actually goes back to the broader questions around data protection and privacy, which you started off. And what I was saying when I meant, so, you know, the point I was making with data protection and privacy is very dependent on the culture and the broader political economy and just culture in a specific country. The US I think it will be much more difficult for the US to pass federal data privacy or protection legislation than it was in Europe because of a number of issues. The kind of focus on individual rights, the conception of privacy as more of a right to be left alone rather than thinking about this from protecting individuals from the state, but also from kind of each other, right? There isn't the same backdrop from World War II that there was in Europe that prompted the need to have this kind of approach. California passed the California Consumer Protection and Privacy Act in 2018. It was meant to go in force in January 2020. There's been, it's been interesting. I did a little bit of research on this topic as well. There isn't much that's been written. There is a big question about how the enforcement of the act will be affected by COVID, because again, there's this perceived trade-off between being in an emergency situation and having to derogate from certain legal provisions and rights in a situation of acute emergency, and the kind of reporting burden and onus that results from these legislative provisions. So a lot of the analysis has just been kind of wondering, since, you know, it was only supposed to come into force in January, how the implementation might be delayed as a result of the COVID pandemic. I think that the Palantir example is sadly, is a very classic example of a lot of related questions and issues around transparency, accountability. You know, there's a whole question about corruption aspects in our kind of procurement systems and things like that. But really, what it very much would be surprised to see Palantir having a rights-based approach to this. If you remember from a few months ago, the story about the I think it was Clearview, that the facial recognition company, right? I mean, that to me brings up echoes of those types of companies, where scraping of social media using facial recognition techniques, which by the way are one of the additional risks, obviously, to the COVID response. I mean, if your data protection can be eroded if using any kind of personal data, but obviously the risks increase if you use sensitive data that includes biometrics. So I would be very worried about this for a number of reasons. And I think ultimately in the absence of a formal legal framework, we need to rely on companies to be responsible. And that's where the business human rights framework comes back. But it obviously depends on willingness for the private sector to engage in responsible corporate practices. And Palantir, to my knowledge, is a defense contracting company, or it has links to the defense industry. And we know that the practices in that industry tend to not be particularly conducive to applying a human rights-based approach. So I'm sorry I don't have a more positive answer to your question, but I would be monitoring very carefully if it were me.
Yeah, I didn't expect you to be positive on that one. So we have three questions that have come in, all of them very interesting and very different. So I'll start with a student of Professor Schneebaum's and mine from Sam Davidoff Gore, who's graduating this semester. So his question is about Singapore. So so we've talked about the centralization of data collection in Singapore,
Yeah.
but we're seeing it also in Europe. Can you comment on the desire of some of the European countries to have centralized data collection and how the EU's directive, the GDPR, addresses this?
Okay. Do you want me to take questions one by one, or do you want to take a number and then?
One, because the next one is more on, well, the next one is on algorithmic bias, which is very interesting.
Yeah.
Well, might as well give it to you, but it's interesting because it's from an epidemiologist studying at the Bloomberg School and conducting projects on infectious diseases surveillance for the School of Medicine. So we're happy to have someone on SAIS related here. So yes, that question of algorithmic bias that we talk about in classes, he says, I'm aware that they're being increasingly used to predict COVID outcomes, but there are some major methodological challenges. Absolutely. I'll let you take both of those questions.
Sure. So thank you very much. The question on centralization is very interesting. And, you know, I probably only know a partial picture of the Singapore story, so I'd be very happy to either be corrected or be given, have this be, you know, provide nuance provided to my initial very high level overview over there. But I think what's the difference between the approach taken in Singapore and the EU, I mean, it's hard to compare because when you're dealing with the EU, you're dealing with a federated system that is trying to harmonize rules across a continent. The approach the EU has very much taken has been there's been a collection of rules and flexibility within the EU as a result of that harmonization, and then there's what happens with countries that are outside of the system. So within the, I would argue that it's not as much in the EU about centralization as it is about interoperability. And in fact, the EU toolbox and a lot of the kind of press releases that the Commission has been putting out that coincide with the broader digital work that the Commission has been doing is really focused on creating interoperable systems. So when you have interoperable systems, the systems in practice basically talk to each other. You need common reference data, you need common standards and systems to make sure that you can cooperate. The benefit of an interoperable system rather than a centralized system is that you can link the data sets when you need to link the data sets, as long as each individual data set is protected. But you don't need to centrally store all data in one database. Centralization has implications for government efficiency, etc. But it does increase the risk of misuse, and it increases risk to integrity of that data because it's stored in one place. So I think that actually it's, I think that the interoperability focus of the EU, particularly when it comes to the COVID response, where they're trying to ensure that they provide both harmonized rules and regulations as well as technical standards to ensure that the monitoring can happen across the EU, the continent, and kind of the broader, the European Union, while avoiding potentially some of the risks associated with a fully centralized system. But again, it's hard to compare a national level system with a multinational level system. I hope that provides some answer to your question. On algorithmic bias, first of all, I mean, I'm sure we would learn much more from, and it would be super interesting to understand the infectious disease approach to this and kind of where the priorities lie. And again, I think this is one of the biggest challenges about this field. It's each actor within this collective group and ecosystem has its own needs, short-term needs, and as a result, different prioritization of some of these issues. So, you know, while these data protection issues are particularly important for a human rights lawyer, they might not be in terms of weighting the kind of cost benefit of focusing, you know, unduly in the short term versus getting the right analysis done in the long term for the collective good. People might, depending on their fields, might have different ways of dealing with this. But in terms of specifically algorithmic bias, can you remind me the specific question?
So yes, and by the way, I didn't say the name of the person. It's Alex John Zapf.
Okay.
So could you expand on algorithmic bias? He's aware that they are being increasingly used to predict COVID outcomes, but there are major methodological challenges.
Right. Okay. So again, a human rights lawyer by background. I'm not a technologist, so I can't go into the weeds on the way in which these algorithms are designed. But one of the key elements that leads to algorithmic bias is, well, there's two things. One is the quality of the data that's fed into the system. And this brings me back to the point I was making about the digital divide and the need for inclusive decision-making. If you don't have a portion of the population covered in your original data set because the data you're collecting doesn't collect data from those people, either if you're using technology that uses, an operating system that's too new and therefore you don't target vulnerable people, then the data you're feeding in is biased in that you're not covering the whole picture. And so whatever decision-making comes out of automated processing will reflect only the data, the quality of the data that's fed into the machine learning system. So I think that for that reason, one, our move towards AI-based decision-making, particularly in the context of health surveillance, cannot be done at the expense of other forms of kind of more analog contact tracing. Without using tech-based contact tracing and AI-based tracing or other means for health surveillance, we won't have the manpower necessary to do this fast enough. But because of the risks of bias, I think it's very important to ensure that we're being holistic about how we approach it and use lower tech solutions as well to ensure that we're getting the right data. What's interesting about the algorithmic bias question is kind of also broader considerations about fairness and accountability. So, and a lot of the OECD principles, the UN Convention, GDPR, and other instruments have a provision on automated decision-making processing. You should have a human being checking the results of automated decision-making. And one of the key challenges with AI-based decision-making is the fact that these algorithms are considered to be black boxes, where there's no transparency about how the decision is made. And so having an auditing function of that algorithm is important to ensure that that bias is caught, if it is, and that there is a vehicle for redress that is real, because you don't know how are you going to be able to actually seek redress. So those would be the two ways from a legal perspective that I would see them. Obviously, I'm sure there are tons of biases in the potential biases in the methodology and the way in which these algorithms are designed, but I'm not a technologist, so I can't answer to that effect.
We do talk about the issues of algorithmic bias with facial recognition technology, and it touches on what you're talking about. The false positives within the African American and Asian community are extremely high, right? So that could lead you to a double arrest for who knows what, just because everyone looks like the other, and that has been a real problem. And there's algorithmic bias because what goes in comes out, as you were saying, and there are very few programmers who are women. So there's another gender-based algorithmic bias, which is a real preoccupation. It might not be linked on this particular issue, but there are so many issues still with algorithmic bias that need to be discussed.
Amazon had a huge issue with that.
Exactly. And the right to redress is fundamental, because if, like, on job applications or these kind of things, you don't know why you got turned down. And some of my smarter students have told me that they know how to write their CVs in a way that will, the women, how to write their CVs that it would get through the gender bias algorithmic detection. I don't know. Anyway, we have another question from Manmeet Dinsa. So some mention on the different applications and technologies being used to address COVID, turning data that is collected passively, such as through social media scraping, which worries me totally. Is this occurring in the United States? And what are some examples of these apps and techs?
Sure. Yes, I mean, the short answer is yes. There was a recent Washington Post article in March, late March, that showcased the fact that the US government was in talks with most of big tech to figure out how to create apps that would help with this contact tracing. I mean, in general, and Facebook, it was Facebook, Microsoft, Google, etc. In the problem fundamentally, the issue is that there is a lag. We're in a situation of crisis. There is a sense that you need to act fast and that you need data to engage in evidence-based policymaking and decision-making. And often you find that the traditional mechanisms for data collection, where you would go to the doctor, your healthcare professional would feed that information to the CDC, and the CDC would then be able to have aggregated statistics on healthcare trends in the US, for example, that is done. That is a mechanism that is done, but that results in a lag of data. We saw this example very clearly with the Kinza Health. There was a smart thermometer that was basically was able to use its data sets and partner with various companies to create a database and a map of the spread of the coronavirus in communities, and was able to map the 2 weeks or something before CDC. The CDC could, but also before predict basically where the new hotspots would be on the basis of fever spikes. And we're able to show as a result, both kind of predicting where the new hotspots would be, but also we're able to show the effect of social distancing measures on reduction in fever. And it was very interesting because, that data that was collected, I would be very surprised. I mean, it was probably somewhere in the terms and conditions, but those terms and conditions were written in a way that those rights were completely sidelined or buried in a very long T&C document. And that really brings up the main fundamental, and so on the one hand, it's very useful to use this data, because if you have to wait for the CDC, you're not going to be able to communicate. Governments and policymakers need evidence to be able to make decisions in a way that are justified. And so the faster you get data, the more you can react and change and change policy. On the other hand, if you're using data that is collected passively, then that shows basically the limits of the consent framework that I was talking about earlier. And I think one of the key aspects to consider in this consent debate is consent dead when you start using passive scraping and other forms of data collection that are not, where it's not possible to consent. And the other flip side of that, and that goes back to the business human rights approach, is consent is really, to me, to be really effective, needs to be modeled on the FPIC. Free, prior, and informed consent.
My students know about FPIC.
Right? So prior informed consent, informed consent, having signed off your rights in a 100-page terms and conditions document where you don't actually know what you signed off. And I'm a lawyer, and you're a lawyer, and Stephen's a lawyer, and I can pretty much guarantee that none of us ever read the terms and conditions before we click on something. No. This shows the limits of consent. And so to me, we can lament that, and that's where I'm going. I'm trying to think about ways to reform our data protection frameworks to be cognizant of those limitations, knowing that this is the kind of data that is being predominantly used and collected by the private sector. So how can we create safeguards that don't require you to consent? Because we know consent is limited in a lot of cases. So that's a whole other presentation, and I'm not going to go into it today, but it's definitely on my mind.
We have 2 more questions, and then I'm gonna throw it to Professor Schneebaum, whom I'm sure has lots of good questions. So one from one of my students, Midori Tanaka. So she's asking what if government blocks citizens' access to information on how their data is being used under the auspices of national security? The government has an extreme culture of classification secrecy. By evoking the oft-used excuse of secrecy, they may easily sidestep, as they have in the past, any legal responsibility to disclose data use. She's thinking NSA. That's the first part of her question. Then she also wanted to know more about the process of anonymization and data de-linking, which is a huge topic that you talked about.
Yeah. Okay. Easy questions.
Easy questions.
We have 5 minutes.
So we might go over. Well, we might go over by a few if it's okay with you. With your
I have a 12:30 meeting, so
yes, by 5 minutes.
Fine, 5 minutes. So secrecy and data classification, yes, and this goes back to the discussion, and the reason I raised access to information is it was to start kind of foreshadowing these issues. And these are particularly important in the context of surveillance, but broader civil liberties. Usually the way in which government classifies what information can be shared or cannot be shared, either under an open data regime or access to information legislation, is through a data classification policy. And as you mentioned in your question, or kind of alluded to, there are generally, I mean, there are many ways to classify data, but one way is to classify it from sensitive to open. The question is, how do you determine, and how strictly do you determine what is sensitive and what isn't? And if you classify everything as sensitive, then it doesn't matter if you have an access information law or an open data policy, because none of the data is going to be considered to be open enough to be shared. So, and I think this is really one of the challenges that I wanted to raise in raising access information. Part of it is legitimate need to reorient resources towards COVID response. And so you can't spend as much time as civil servants asking people to publish information. But if that is if an emergency derogation from access information is being used to control that information illegitimately in order to surveil, in order to reduce transparency, reduce accountability, then you're not meeting these rule of law criteria of necessary and proportionate. And so that's where I think you need to, I mean, it's what's difficult ultimately is that are the conditions and standards that I have described that come from a rights-based approach. If you're dealing with a regime that does not follow a rights-based approach, we can, from our external perspective, lament the lack of implementation of these standards, but they do not work or are not recognized in the domestic context. And so it is, that's why I say ultimately you need the whole ecosystem to function, the whole rule of law ecosystem to function, not just having specific robust law on paper. You need strong courts that abide by rule of law. You need independence between the judiciary, the executive, etc. And you need to have all of these safeguards, institutional safeguards, as well as legal and regulatory safeguards to be able to overcome these questions. But it's a very good backhanded way to control information. But again, ultimately, if you think about it, coming back to trust gets further eroded the less information, open and accurate information gets published and disseminated. And so you do risk, as an authoritarian regime, limiting information on the basis of secrecy, that your population may end up rising up against perceived injustice, lack of application of these standards, and lack of transparency. And in a system where you need people to participate, to actually and cooperate to resolve this pandemic, it would be probably in the government's interest as well to cooperate, and that starts with open communication about accurate data. Anonymization and de-linking. So the big debate is really about anonymization at the source versus other ways of protecting data. The old, still current data protection regime argues that if you perfectly anonymize data at the source, it no longer is considered to be personal data. It becomes non-personal data, and then it is no longer subject to the safeguards that are afforded to personal data. This is, the more tech is evolving and the more our data uses are evolving, the more this concept is being eroded in its efficacy, because it's very easy to re-identify people. There's a very good article by a team of researchers from Imperial and MIT, led by Yves-Alexandre de Montjoie, called Unique in a Crowd. And it basically shows that with using trend data, you need 4 data points to re-identify anonymized data. So, read that, and then you will never be able to look at data protection in the current status in the same way. So I think the way in which the field is evolving is now thinking about, well, privacy by design through technological means, and thinking about ways to store data with the individual to provide the individual with more control. Relying simply on anonymization and aggregation is not considered to be to be useful, and even the distinction between personal and non-personal data is being eroded as we mix and link data sets from different sources, including kind of passive scraping, and even data that on its face is not personal or personally identifiable information linked with another set of data sets can lead to the derivation of insights that would be sensitive and that would be able to target people. And so the question to me is not as much about whether you're dealing with personal or non-personal data, it's how that data is being used, and is it being used in a responsible way.
Last but not least, that was fantastic. Last but not least, our very own head of the iLaw department, Professor Schneebaum, who I remind all our listeners, gave an incredible presentation exactly last week on these issues of constitutionality in times of COVID. So a lot of this has interlinked with the discussions on the GDPR. But Professor Schneebaum, I leave you the last word.
Well, thank you, Nina and Adele. That really was
Fantastic.
Spectacular. Thank you so much for doing this.
My pleasure.
So look, I am interested in, so to speak, the political ramifications of some of what you've said and the legal ramifications of it. Looking from the bottom up, looking from those people that you defined, I think quite correctly and perceptively, as on the other side of the digital divide.
Right.
Yeah.
To the people who on some levels have the right to consent to the collection of their data. They can agree to participate in a survey, or they can agree to have directly in interaction with another person to permit their data to be used. But to a large extent, they are not asked for their consent, right? They are simply being observed. And because they are simply being observed and never agreed to be observed, but simply find themselves in that passive position, I suspect that there is a lot of powerlessness that feeling engenders. And of course, we've seen in our country in recent times that divide, which maybe tracks the digital divide, being exploited for political purposes. I mean, after all, there's been so much talk over the last couple of weeks about the origins of this sharp division in our country. And some people trace it back to the feeling reflected in the sainted Ronald Reagan's pronouncement that government is not the solution to your problem, government is the problem. So if government is the problem, then government can't be trusted. And if government is collecting my data, or if government is permitting private actors to collect my data, the only thing we know is they're going to misuse it. I have no control over it. I am being watched. I am being spied upon. And that can lead to no good. Where does that end up? And how can we derail that progress if we're going to be able to restore a more participatory democracy in the digital age?
Wow. Thank you for entering the ringer.
Yeah, you have a 12:30 call, I know, but
we can
that was
wow. Well, I would love to have a follow-up discussion over one of our long coffees or drinks when we are allowed to do that in person again. But in the interest of time and giving a flavor to the response, it's a fundamental question, and it really raises kind of broader questions about the role of social media platforms and kind of internet governance in the rise of populism and response and trust in institutions, private and public institutions. To me, it also raises, and I'm going to spin the question a little bit, because I think that it does have ramifications from a political perspective, but I also think that those ramifications are in some ways limited by another aspect of that digital divide, which really is the source of it, which is digital literacy. And I think that to a certain extent, you can only be aware of your rights if you are literate about, and you are knowledgeable about them and literate about them. And so I would actually counter or push back a little bit on this assumption that everyone knows they're being spied upon, they're being surveilled, their data is being collected, or they even care. Trust is a fundamentally important part. But I think, and there's been a lot of interesting studies done about a year after GDPR was put in place and enforced, that surveyed users and showed that you know, a year after GDPR, people actually care a lot more about what's happening with their data than they did before, because part of the legislative process involved a very strong communications campaign about those rights. And so I think that ultimately you need a certain degree of digital literacy, but also literacy about your own rights and those respective obligations in order to really feel like you are being wronged. A lot of people just go about, don't really realize how much data is being collected from activities that they consciously agree to do, going on Facebook and checking social media without realizing the implications of that. And that's where, you know, as much as we say there's no role for government because government has failed, that is where government needs to play a role. What I would argue, though, is actually it's the way I think around this is actually to engage with these issues in a multi-stakeholder way. And that raises the question of participatory governance. And going back to the last slide, I had the UN guiding principles here, and I had laid out, you know, the government responsibility to protect, corporate responsibility to respect human rights, but then the role of civil society as the canaries in the coal mine, the advocacy, playing that advocacy role, the monitoring role, playing a counterweight role to government and to the private sector. And the more we bring those three stakeholders around the table, the more the rules and regulations and standards and frameworks that are developed will respond to the interests of those parties. Right now, we're in a political economy situation where the government doesn't have, there are institutional constraints, but there's also knowledge constraint. Very few people in government understand the technology side of things. Technologists and the big tech companies have dominant economic power and the technological knowledge to develop tools and processes that are not understandable by anyone but themselves. And we are in an era where, like years leading up to the financial crisis, we're dealing with a very light touch self-regulation model that assumes that the private sector has the right incentives. And until we change corporate governance standards, and until we engage in participatory and multi-stakeholder governance that includes individuals and civil society as well, and those interest groups, we're not going to get out of this impasse, and we're going to continue to see a polarization. So hopefully there is hope if we reform our governance processes, but it could go both ways. I really believe that we are at a crossroads here.
Well, I think with this we'll close. And Stephen, you want to do a shout out for our next panel?
Thank you. And again, thank you, Adele, very much. Thank you, Professor Gardner, for making this happen.
Thank you both.
All of you are invited to participate on Saturday in a Zoom webinar being hosted by our colleagues in Bologna. This is, as some of you will know, alumni reunion weekend in Bologna. And a series of discussions is being promoted out there. One of them is being run by the iLaw program, and that concerns human rights and migration. It starts at 9:30 a.m. East Coast time, Eastern Daylight Time, 3:30 p.m. in Europe. The panel will be chaired by our colleague Justin Frosini, and will include two of our iLaw professors, Susanna Mancini and Sarah Panicino. So we hope to see you, all of you, or as many of you as possible, participating in that event on Saturday. And perhaps at the end of that event, or other time soon, we'll be announcing some more activities that the iLaw program will sponsor between now and the end of the semester. So thanks to everyone for participating. Thank you, Professor Gardner.
Brava. Thank you, Adele. That was wonderful.
Thank you very much to both of you. Have a good day.
Have a good day.